Good afternoon, everybody. Thank you for signing up to listen to our client seminar today entitled Innovator's Guide to Patent Strategy. Welcome. Hopefully you're getting a good feed and hopefully you'll get some good information out of the session today. Just in relation to questions, please put them through on the chat. We may opt to answer some of them at the time they come through, or we may leave others to the end, so don't despair if your question hasn't been answered as soon as it comes through. So we will pick and choose if there are some questions that are needed to be answered straight away. Okay. Presenters today, I apologise, these photos, as you can tell, are a little old, but it'll be myself and Peter Franke, so we'll both be taking different sections of the presentation, and I'm sure those of you who know us will be familiar with our presenting style. An outline of what we're going to talk about today. So what we really wanted to do is just go through the process of deciding how to set up your intellectual property strategy, particularly around patents, and in this presentation, particularly for small or early stage products and inventions. So there are a number of areas we're going to talk through. We're going to talk through why you need a patent strategy and what exactly do we mean by that. Talk about other issues that come up, such as ownership and control of the IP, talking about searching, whether to do it and what types of searching you should do, the preparations and the requirements, our requirements for filing a patent application, deciding what aspects of your product or your technology to protect, and that then leads on to talking about what types of patent applications you might want to file in the first instance, talking then about the Patent Cooperation Treaty and other national application procedures that come further down the track of the application process, and getting into some detail about examination issues that arise while we're undergoing that application process, talking about some of the grant or allowance or validation procedures that are then required at the end of the examination process. We're going to talk a little bit about ongoing patent portfolio maintenance. And we're also going to have a little look at freedom to operate issues that arise. And the way we're going to do this is we're going to talk generally about some of these areas, but we've created two hypothetical case studies that are fairly typical of the type of things that we'd be dealing with in our practice. And what we're going to try and do is, once we've talked generally about an issue, is show how our consideration of that issue applies to that particular scenario of the particular product and business that we're working with. So it gives you a bit of an idea of how some of these considerations that are in the background apply to your situation and the type of decisions that we might make about how we would set up your IP strategy and the type of things that we would need from you to do that effectively and to do it cost effectively particularly. Okay, so the two case studies, what we'll go through is set up the scenario for these two case studies so you understand where both of these are coming from. One will be, Peter will be taking you through one and I'll be taking you through another. So to start off with, this is our first one, which Peter can talk about.
Good afternoon, everyone. Yes, so I'll just make the point to start with that at one level we would like to be running this based on actual specific client experiences we've had, but for obvious reasons we can't do that, so hence we have these imaginary case studies. Forgive us if they don't seem to be very good inventions, but then that's not our responsibility. Nosy is a passive, the illustration here is maybe not ideal, but anyway, it is intended to be a kind of a passive, externally worn sleep apnea treatment device. So the company is a startup. It has done proof of concept at a lab level, but and it's not exactly a competitor for the large-scale CPAP machines. It's a sort of a simpler product for a less severe form of the condition. So the original technology was spun out from Ryde University. There's been several further improvements, and then industrial designers have done a fair bit of work on it as well. So there's, some complexity there. Just the nature of the product is that it needs regulatory approval, which means it will need extensive clinical trials, so they're going to need to raise a decent amount of money at some point. The major markets are the places you'd expect, US, UK, EU, Australia, Japan, Canada, China, that sort of countries who can afford this sort of a product. But equally importantly, the competitors are large players, and that really colours what's required here. So, people like ResCare, Philips, Fisher & Paykel, GE. So, and these people have big IP portfolios, so, you kind of can't hope for the best. The business model that the client's proposing is a direct online sales model, powered by social media.
Okay, and over the years I've dealt a lot with different types of commercial food products and functional ingredients that go in those commercial food products. So I've created this scenario for a healthy snack product. The product is called Pear Me. So basically what it is a product that's got a new botanical ingredient in it based on or derived from the prickly pear that helps to increase the feeling of fullness. The snack product's going to be an extruded cereal-based snack product using otherwise conventional ingredients that we normally use in those type of products. We're going to shape it like a prickly pear leaf to tie in with the functional ingredient in the product. So our client is a medium-sized Australian food manufacturer already marketing and distributing similar types of products in the snack food area. They've got some export markets in New Zealand and Southeast Asia. Its main market is in Australia. This product has potential possibly via licensing the technology for sales in other territories, but the client's not intending to set up factories and worldwide distribution, at least at this stage. The product itself has been developed in-house, but it was inspired by a CSIRO article on the potential uses of the functional ingredient. The product is fully developed and ready to launch at this stage, so we're just about to hit the market, and they want to go ahead as soon as possible. And they also want to be ready to assert IP rights early in the life cycle of the product, because sometimes these products only last 2 or 3 years. So any IP rights are going to have to be usable pretty much straight away, and particularly in Australia and New Zealand, where they see their main market opportunities. Okay. So just generally speaking about IP strategy, what is it? And particularly with regard to patent strategy. The most important things we need to know is how are you going to make money out of this product? The whole idea of protecting your IP is to protect the investment that you've made in research and development. And the idea is you're going to have a commercial product, and what we want to do with the commercial product is make money. So the best IP strategy will be set up to protect the things that are going to net you the most return out of the product, and to keep competitors potentially at bay from immediately jumping into the market and copying your product and thereby taking your competitive advantage away. And also aspects that may well be potential licensing opportunities where other competitors, perhaps or people in other markets, may want to pay you to be able to use your technology. So the things that we really need to know are, what are you selling? So in some cases that's fairly obvious, but in some cases, it's not always necessarily a straightforward idea as to how you're making money out of the product. What's the business model that you've set up around the product or the process? And also, what's the exit strategy? This is really important because, on the one hand, if you're planning to build a factory and manufacture this product for decades, that's one business strategy, and that would lead to one type of IP strategy. But if your plan is to simply test the market, prove the product, and then hope to be bought out by a larger competitor or company, then that would lead you down a different path for the type of IP strategy that you need. So these are the things that we really need to have as good an idea as possible of at the start of the process, because this will guide how the whole patent strategy gets set up. So there are a number of different elements of a patent strategy, things that we need to deal with. Ownership and control of the IP, we need to look at that. These things are not always necessarily straightforward. Sometimes they are. If you've created a product yourself and you're going to sell it to the market, then that's a relatively straightforward thing. But sometimes there are outside inputs, people such as contractors or designers who have got an input into your product, and we need to actually know what those are, and so we need to be able to design an ownership and control strategy around the IP, because there's a number of things that need to be addressed there. We need to identify what aspects of the product that need to be protected. Is it how the product is made? Is it the product itself? Is it how the product is marketed? Are you protecting, do you have a product that you're going to be selling, or are you going to be giving part of the product away and selling consumables, for example? These type of things need to be considered. So that then leads us on to what type of IP is going to be needed to protect those different aspects of your invention. We need to think very carefully about the timing and location for filings. There's never a perfect time to start your IP application process. Usually we've got to do things probably quicker than people necessarily want. We don't always have the luxury of having an enormous amount of time to get these things going before the product either has to hit the market or before the product has to be disclosed for some other reason, such as regulatory approval. We need to have a risk management strategy in place around other people's IP, because it's all very well to get your own IP protected, but it's not very good if you're running into a roadblock of someone else's IP. Cost budget is always an issue. Really a big part of what we do is trying to figure out what's the most cost-effective way of spending your money. It's great to have unlimited time and unlimited budgets, but we usually don't have both of those, and we usually don't have either one of them. So what we need to be able to do is figure out what is the best use of your money to get the maximum protection that's going to be most commercially valuable. Other ongoing things that need to be considered in IP strategy is policies and procedures of how you manage that IP in an ongoing basis. And also there are some other IP specific steps around commercialisation, such as licensing, publication, due diligence. For example, if you're going to be attracting investors, we need to make sure that your IP portfolio is set up so that you're able to answer their questions and so that it looks investable, for example. Right, to dive in a little bit closer on ownership and control. Very important, because it's one thing that sometimes can't be fixed later if it isn't set up properly in the first place. We need to know who owns the IP now and who should own it. And what we mean by that is, where has the IP right been derived from? One of the fundamental things with IP rights is that they are derived from the individual person who has created that IP right. So, for example, if we're talking about a new technology, the inventor, the individual inventor or inventors are the ones with whom the IP rights start. Now, very often you will be commercialising these by having the IP rights owned by a company, but it's very important to actually make sure that we get the right chain of title from those individual inventors to the company that is going to be commercially exploiting that IP. So what we will then need is a proper chain of title. So this can sometimes be straightforward and sometimes not. If you're operating an R&D group within your company and everyone's job there is to produce new technology for commercial exploitation, it's a fairly normal thing for the rights of the inventors in that group to pass to the company that employs them. Typically in Australia, that's how it would work. But if they're not employees, it can be a little bit more tricky. So if we're talking about contractors, IP rights created by contractors are generally not owned by the person who's paying them to do that job. Those IP rights have to be transferred separately. Similarly, if the employee of the company is not actually employed to do R&D but is in a different area and they create something that's valuable to the company, then they don't necessarily automatically transfer title to the company. That may need to be done as a separate step. And also, very often we're dealing with people who are directors of companies but not actually employees, and the same would apply there. We need an actual direct transfer of the inventorship rights from that director to the company. It's not something that can be assumed to happen automatically. Other issues around ownership and control is who should own it. Normally, in the normal course of events, the IP would be owned by the company that's commercially exploiting it. So a patent would be held by the manufacturing company that's manufacturing the product and sending it out into the marketplace. But there are other reasons that you may want to do things differently. Quite often people will set up an IP holding company to own all of the IP. That's in some ways not always the best way to deal with things from a purely IP point of view, but it may be a better way to deal with things in terms of product liability or other accounting or financial transaction considerations. We really do want to vest the owner as far as possible in the right individual at the start, so in the right company. Now, this can change along the way, and sometimes it's easy enough to transfer ownership of the IP rights to a new owner as the commercial plan evolves. But to the extent possible, we want to make sure that the right entity owns the IP from the start. For example, sometimes the IP rights start off being owned by the individual inventor themselves, so someone may actually file a patent in their own name, but later on discovers that they want to transfer that right to a company because what they want is someone to invest in the company. So investors are really only going to be interested in investing in that company and its IP if the company itself owns the IP, not if another party, such as the original founder, still owns the IP in their name. So this will lead us on to needing proper shareholder, founder and director agreements to make sure that IP rights are correctly managed. We definitely need proper employee contracts to cover IP. A lot of employment contracts will say things like, I agree to transfer any IP that I create to the company, which is good, but that in and of itself doesn't actually transfer ownership of the IP to the company. You then have to come back with a transfer agreement at the appropriate point to transfer those rights to the company. Non-disclosure agreements and research agreements with external partners are extremely important. One of the issues with filing for a patent is that it's got to be new at the day we file it. But if you have already made a non-confidential disclosure to another party who's not obliged to keep that information secret before you've filed your patent application, you may have already invalidated your patent application at that point. So really important to make sure that those any disclosures that you need to make to other parties that are not part of your organisation are protected as far as possible with the right types of agreements.
So in the context of Nosy, there's really two particular areas that leap out from that scenario. So the original technology was spun out from Ryde University and then it's been improved. So the first set of questions is around making sure that there's a proper license or assignment agreement with the university, and also to see evidence that the actual university inventors have assigned their rights properly to the university before it's come out to Nosy. I know some of the people in the audience have been down this somewhat unpleasant path, and it can be quite a business, particularly just being aware of the bureaucracy and politics of universities. So the earlier you get onto this, the better. A particular risk with universities is students, and you would think, well, why is that a risk? The problem is that students aren't employees, so their inventions or their contribution to an invention is not assigned to the university unless there's an agreement that says otherwise of some sort. And I've certainly seen several occasions where a whole deal has fallen over because the student doesn't want to play ball for whatever reason, and they're properly named as one of the inventors, but they will not assign their rights. So it is a bit of a hazard. It's not to say students shouldn't be involved. You just need to have a proper agreement before they start inventing anything, if you're the one paying the bill. The second issue is industrial designers. My experience is there's no particular issue there. Generally, their standard agreements will transfer IP, and that's part of their business model, really. But you do need to make sure that all of the actual folk who've worked on it at the industrial designer, ideally you get them to sign an assignment. And certainly you need to make sure they're employees and not contractors, because it tends to be a little bit volatile. People will work in one country for 2 or 3 years and they'll move, and you find yourself 3 years down the track trying to chase a signature from someone who nobody quite knows where they are, and they're backpacking in Guatemala or something. So there's just a bit of cleaning up. It's not a particular problem, but it just becomes an impediment to getting things done. Back to you, Adam.
Okay. So for the PME product, what we need to do is to make sure that those product developers who created the product in-house are actually employees. And if not, then we need to make sure that we get assignments of their authorship or inventorship directly to the company. Also, because I mentioned that it was inspired by a CSIRO paper, we need to look into that and to see to what extent the authors of that paper and the suggestions they made in that paper could see them considered as potential inventors. And if they are, then that would potentially complicate how we need to set up the ownership structure of this patent. And also, because we're dealing with a natural product from an existing plant, we probably should also have a look at any traditional knowledge aspects of dietary use of that plant. It is not the traditional knowledge area. I think is one that's going to be growing in the future. For example, I've noted that whenever we file a food-related patent in India, there seems to be a group in India that is set up to identify these and immediately launch an objection that the product or that the invention shouldn't be patentable because it's based on a natural product. And I think we're going to see more and more of that kind of thinking into the future, particularly in countries, for example, in Australia or New Zealand, where there are traditional knowledge aspects that relate to native plants that are going to need to be dealt with. Okay, question that we often come up to in the first stages of getting a patent application ready is, should we do a search or should we file first? It's always great, as I mentioned, if you've got all the time in the world and all the money in the world, you will do an enormous amount of searching to make sure that what you've got is patentable, and also to make sure that there's freedom to operate. But in the situation that we usually find ourselves in, where we don't have unlimited time or money, what we need to do is figure out what we really should be doing with regarding to searching prior art to see what's already out there in this technology field. What we need to think about is our timeline to publication or to market. So at some point, the product is going to have to go out there, it's going to hit the market, or it's going to need to be shown to someone in a non-confidential way. We need to make sure that we've got our applications filed before that point. So we need to know what that timeline is going to be like. Also, an important thing, is the technology fully realised? Do we have an exact idea of how this technology is going to work in the marketplace? Or are we still developing it? Do we still need to do more work before we fully understand exactly how to replicate and commercialise the technology? How well do we understand existing and competing technologies and products? This is very important. We need to know the landscape and the commercial and IP landscape that you're operating in, because that will determine whether or not we need to do things very quickly, whether we need to get applications filed as soon as possible, or do we have some time to consider things fully? And what other IP do your competitors hold? As we mentioned, freedom to operate, which we'll talk about in detail later in the presentation, is always an extremely important thing to think about.
So in terms of nosy, we've already identified that we're in probably a pretty patent intense space. So it's really important to do some thorough searches right up front. And that's probably a higher priority than getting it filed early. If the searchers identify that one of these major players has got a suite of patents that make it pretty much impossible to get this product to market for whatever reason, then the sooner you find that out, the better, before you've gone too much further down the development pathway. But even apart from a roadblock like that, it's just nice to know what's there. So if the inevitable question comes up from an investor or as part of due diligence, then you've got an answer for them, rather than, oh, we just haven't looked into that, we'll worry about that later. The second thing you want to get out of the search in this case is ideally to think about who might be a partner or trade sale buyer or some other mechanism to fund the clinical trials and ultimately the IP as well. It's not going to progress anywhere unless you can do the clinical trials and therefore get the clinical approvals. Much for many medical devices, much like in a smaller scale version of pharma, the closer you are to being able to sell a product, the more the dramatically more the business becomes worth. So having a grip on those two aspects. So you might identify someone who's in a not dissimilar space or looks like they're trying to launch into this kind of passive sleep apnea space, and they might be someone very interesting to talk to who might want to be interested in doing a deal or taking equity or just buying the whole thing.
So for PME, because we're about to hit the marketplace, we need to conduct some IP clearance searches immediately. So we need to know straight away whether or not we're going to run into somebody else's IP that's already there. It's probably less important to do a lot of comprehensive searching to find out whether or not what we've got is actually patentable, particularly if our main markets are in Australia and New Zealand. It'd probably cost us less to draft and file the application in those two countries and find out what's going to happen and see what happens next than it would be to actually do a completely comprehensive patent search. So in that sort of circumstance, we would just take the option to do a shorter clearance search, just to make sure that we're not going to run into any immediate patent infringement issues. And then take the odds to then filing the applications early in Australia and New Zealand. And then if we head on to examination of those applications in Australia and New Zealand and they look clear, then within 6 to 12 months, we might think about filing other international applications if the product seems to justify that as a step that will be taken later on. Okay, getting ready to file. What do we need to know in order to get a good, solid patent application drafted and filed? Certainly we need to know the stage of development of the product. Is it completely ready to go, or are there more experimental procedures that need to take place? And also we need to know how long before public disclosure is unavoidable. We usually end up in a bit of a tug of war between these two issues. You would generally like to leave filing as late as possible in order to make sure that you are as fully developed and in control of the best method of performing your invention as you can possibly be. But we usually can't always get there at that time, because at some point soon we're going to have to hit the market, or we're going to have to make some kind of non-confidential disclosure of the technology. So we usually end up in some kind of a tug of war between those two imperatives. So we need to know what further R&D is required. Are we just dealing with a basic idea, or do we have something that's at a prototype stage, or do we have something that's ready to go to market? That's important to know. What we really need in terms of technical information is substantiation of all the key aspects of the invention. And it's important that we're able to put the real key aspects of the technology in that first application, because you usually can't fix that later. Our first application is the date of filing is the one that sort of sets where in the world of technology our invention sits. And consequently, what that means is we have to have whatever detail around that technology that we have is the level of detail that we'll need to deal with for the remainder of the application process. There are very few opportunities usually to add in more and better information later. And it's certain once we get past a certain point in the application process, we can't add anything new. So we need to try and get as much of the, I guess, the final and full understanding of the technology right at the outset. There was an extent to which in under previous patent legislation in Australia, you could file a more general application at the outset and then improve it later, but that's no longer the case. So even if we're filing a provisional application, we're pretty much going to have to run with what technical detail we've put in that provisional application. The important thing that we want to do in the patent application itself is to compare our invention favourably with the closest existing technology. So it's useful to know what we at least think is the closest existing technology, so we can set up the document to show how what we have got is both new and potentially unexpectedly or non-obviously better than the existing technology. This is the real key to what we need to convey in that patent application. So in order to do that, we're going to need all the technical information you've got, any diagrams of equipment, flow charts, test results, whatever they may be, and however they may relate to the efficacy of the technology. Full details of trials that have been done, particularly those that demonstrate the efficacy of your technology compared with what you're going to be competing with in the marketplace. So every patent application is really telling a story about how there's a problem, how our invention addresses that problem, and at least some data that proves that what we've got works at least a bit better than all the things that are already out there. So anything that helps us convey that story is really useful when we're going through the patent application process.
And particularly where your invention we're going to assert is surprising because this is not what you would expect. Well, you need to have data to support that. Extraordinary claims require extraordinary evidence. So if it's a door hinge, we don't need test results. That's fine. We just need drawings and a description of how it works. But if it's a more complex invention and it's to do with the use of that or the outcomes that it achieves that are unexpectedly good, well, we need to prove that, and that's when we really need to have the good technical detail about perhaps comparison or at least demonstrating that the unexpected result has been achieved. So when you look at NOSI, it's largely, for the purpose of this case study, largely a mechanical device. We'll need detailed drawings and an explanation of the principle of operation. But if we're going to say, well, we actually cure or perhaps reduce the effects of sleep apnea in certain circumstances with the device, well, we need some trial data to support that. And the other thing that's worth thinking about, particularly in this sort of likely to be contested space, I mean, we always assume that you as a client is going to be extremely successful. So that means it's going to be contested and these other big players are potentially going to want to muscle in on it. So you kind of got to think about how else could you do this and achieve the same result. If you changed it, how would you know how to fix it? And putting that sort of information in really gives some more meat to your disclosure. The slightly left field thing, which I've done a number of times, is is getting the inventor to think about if a competitor was to implement this using their existing base technology, what might it look like, and actually draw that up and put it in as an alternative. It seems a bit counterintuitive, but it makes it very difficult for the competitor to say, oh no, they didn't envisage this being applied to this sort of class of device.
Okay, for PME, we've got a product that's ready for market and we need to go straight ahead. So theoretically, we should have most of what we need in terms of technical information from the R&D group. This would include preferred product recipes and the process flow charts that are going to be implemented in the factory and the preferred processing conditions. It's also worth knowing at what the limits of our recipe inclusions and our processing conditions are. It's nice to be able to put in a range rather than a simple target level, and this sort of gives us a bit broader protection, but it also will tell us where, at what is the limit of the invention, at what point do we sort of lose efficacy in the product. If we've got that kind of information, that would be really useful to put in a patent application at this stage. For a product like this, sensory test results are also very important because sometimes if you're dealing with a new ingredient, at certain levels it won't taste too good, so we need to know what type of level we are targeting, both to get an acceptable product in a sensory sense, but also still in a health efficacy sense. And because we're talking a product here with a health, at least some kind of health-related indicator, in this case, a sort of a fullness feeling from eating the product, what we would really need to have is at least some indicative data from actual feeding trials where people have actually given their feedback on how it makes them feel. Sometimes these things are hard to quantify in terms of a numerical number, but if we've at least got feedback data from people who've eaten the product and have given their comments on how it makes them feel, particularly at different levels of inclusion of that ingredient, that's also really useful to be able to include at that outset stage. Okay, what should we protect? There are different ways to skin a cat, I suppose. What it comes down to is what's unique about the product. What's the competitive advantage in this technology? Those are the things that we need to zero in on and protect. So sometimes products have got there are a number of aspects of them, but it's only the ones that are actually going to cause your customers to buy your product and not somebody else's that are really important to be protecting. So what is the market demand? For example, do you have a potential customer has told you they've got a problem or a need? It's very useful for us to be able to write the patent application around that particular problem. The typical way to write a patent application is to set up that there is a problem and that we have a solution to that problem, and this is how that solution works. So it's really useful if we've got a problem, particularly if it's a real life problem, so something that customers have complained about that you are now addressing. The other thing we need to think about too is price point. It's no good having a $200 solution to a $20 problem. So what we really need to understand is how does this technology fit in with the cost structure of that product? Is it something that's going to make it more expensive but better? Is it something that's going to make it just as effective but cheaper? And these type of considerations, we need to be able to understand that to actually write a good patent application. Also, does your competitive advantage relate to unique product features, or does it relate to a different business model or packaging for the material or financial model? So what are the other barriers to entry for someone else to actually get in and copy this product? It's really good to understand that. It's good to understand, for example, whether or not, as happens in medical devices, sometimes the medical device itself won't be the thing that is, your main profit center. You'll be virtually giving them away, but you might be making a lot of money on selling them consumables. If that's the kind of model, then that will also impact on how we actually set up the IP strategy. So we will always try and protect everything that we can. You can't always get what you want, but you can certainly try. what we need to know is, will a customer buy your product, and why will they buy your product and not a competitor's product? What will your competitors try and copy? What type of, your competitor, as Peter mentioned, may have a platform that works for them. It won't be easy for them to change their platform completely, but if they have a way of adapting their platform to use your technology, what would that look like? Should we try and protect that? What are your future product plans? What do you envisage as being the enhancements or alternatives that are coming up to this product? Very important there, we not try and say too much about that. What we don't want to do is shoot ourselves in the foot by saying, oh, in the future we might do X, Y, and Z. And then when we try it, our own prior art, our own patent application is thrown back at us and said, oh, well, you've already said you were probably going to do this, so this is now an obvious improvement. So sometimes we need to sort of keep quiet about what we're going to do in the future to keep the space clear to protect those improved versions in the future. As I mentioned, are there specific components that generate revenue, such as consumables or a cloud service or replacement parts, that will influence how we try and set up the patent strategy? And also, what can be reverse engineered? Is your product, once it's out in the marketplace, completely open to a competitor to pull apart and make their own version? In that case, we need probably stronger protection. Or are there aspects that can be kept secret? Trade secret protection is one way to go. It's difficult and time-consuming to achieve. It may sometimes be the only way you can protect certain parts of your technology. So these are the things we need to think about.
So in terms of nosy, sort of things you'd think about would be the sort of mask configuration, the principle of use. In other words, how is it that it actually, what moving parts are contributing to reducing the sleep apnea. So you're liable to have claims to the product, and you're liable to have claims to how does it work. You could potentially have a method of medical treatment claims, but it's really only the US and Australia that allow those. And the important question here would be whether there's disposable components and whether they're separately protectable. Even if it's not patents, it might be design protection. But if they're going to be sell someone a $500 device, but then every 6 months they've got to spend another $40 on replacement components over the life of the product, you're going to make a lot more money out of the replacements.
And for PME, there are a number of different ways we can protect this new development. And each of these would probably lead to a different set of claims within the same patent application. So, for example, and the other thing I should say is that each of these is likely to relate to trying to catch different types of infringers. So we could have a patent claim to the use of this particular ingredient in this particular food that is aimed at other direct product competitors who are selling food products. Similarly, for a claim to a food containing the ingredient, those are two different ways of coming at the same kind of protection. We could have claims to treatment of a particular condition such as fullness, via a food containing the ingredient. That could be targeted not necessarily at the food manufacturers, but people who are buying the food to give them to certain people, to your customers. So that could relate to, say, a medical situation where your food product, the person's not producing the food product, but they are using a competing food product to achieve the same end. The process for producing the food could be protected, particularly if there are differences in the way you would normally make extruded foods that have to be allowed for to make this particular food with the right level of efficacy that it needs to display. And also equipment that's been modified to produce the food. If we need to actually modify our equipment to make this product in the right way, then that would be targeted as an equipment manufacturer who's making products for other people to copy your food. So the different aspects of the invention, and we'll try and pick as many of these as possible to make sure that we're covering all of the different types of infringers. Okay, different application types. There are three main types that we'll be looking at. First is a provisional application, and this is the way that people typically will start their patenting process, particularly if there's still some development work that needs to be done. So if we file a provisional application, we've still got 12 months before we have to take the next step with either international or national applications. It does allow for an extra 12 months to more fully understand the aspects of the product and to come up with further developments, but at least it provides a line in the sand for the fundamental idea of what your invention is. We then would move on to complete or national application. So if we file a national application in Australia, following on from the provisional, that is the point at which we really can't add anything further. So everything that goes in at that stage is what we're working with then for the rest of the application process. And so what those applications are simply applications filed in each national patent office that you're interested in for the countries where you want to protect your invention. And the PCT application, PCT stands for the Patent Cooperation Treaty, is something we also might file following the provisional application. And what that does is it gives us another 18 months before we have to file the national applications. And why that's important is that each national application will cost several $1,000s to file. And at that point of 12 months after your provisional application, you may not be ready to spend all that money. You may not be completely certain of where you want to file your application. You may not be certain that you want to spend, $50,000, $60,000 on applications in a whole bunch of different countries. So the Patent Cooperation Treaty application allows us to put that decision off for an extra 18 months. So the Patent Cooperation Treaty acts as a bundle of national applications which are then nationalised at that date 30 months from filing your provisional application. So the consideration of why we would file these different ones, do we need speed or we need time to develop and evaluate the market? If we need speed, we'll go national. We've got plenty of money, we've got a product that's absolutely ready to go, we'll file national applications and get them examined as soon as possible. But if we're still developing the technology, we might still be wanting to file a provisional. And if we're still developing our ideas on where and how we're going to protect this and where we're actually making money, we may want to file also a patent cooperation treaty to extend that process out for a little bit longer. And that comes down to what's our market imperatives. Do we need to get out there straight away? Do we need to be able to enforce sooner rather than later? In that case, we would go straight to national applications. Or do we need to conserve our funds and we do still need to actually do some further development? In that case, we might look at a provisional followed by a PCT application.
So, Nosy in a sense is a pretty simple case. They need time. They need to keep their options open. So the smart approach is going to be a provisional application. Clinical trials, just to touch on that very briefly, the clinical trials can't really be conducted in a confidential situation because the patients aren't really obliged to, not tell someone that they're being treated. And in this case, it's not like it'd be a mystery to them what the device was. They'd have to take it home. So you would very much need to be filed before you start doing clinical trials in this case. It might be that products will change as it goes along. You might need additional patent applications to cover those improvements or changes. And PCT makes perfect sense because you want as much international coverage as you can reasonably have during that process because it's more valuable to an investor or a purchaser. But you don't have any, you don't want to spend the money any earlier than you need to. So PCT is the perfect answer.
So for the PME product, because we're in the market right away, we don't need to delay. So we would file a complete application in Australia now and we'd request expedited examination. We'd also file trademarks in Australia and New Zealand right now, file any design applications for the shape of the product in Australia and New Zealand now. If examination of those is looking good once during that next sort of 6 to 12 month period, we would then look at filing the international patent and design applications, thinking about the likely export countries and keep our options open for those countries for that next 30 months. Moving from a provisional to a PCT, so as I mentioned, at that stage, it's going to be our last chance to add new material to the application. A provisional application filed before that has really got to explain and capture, I suppose, the full, our best understanding of what the invention per se is, but we can still add more data and more and better drawings or flow charts or process conditions to our PCT applications to more fully flesh out the best aspects of our technology. So we'd use that opportunity to update any supporting data and add in new and more or better examples of the technology in action. We'd need to make sure that we're showing the best mode of the invention that we are aware of at that time, because that's a particular requirement in some countries. We'll formalise our drawings and figures. We can, for a provisional application, we can get away with sort of relatively informal figures that actually show what's going on, but we need, for the PCT stage, we actually will need proper drawings that are acceptable in all different patent offices. We need to make sure at this stage in particular that all the inventors are identified correctly. We don't have to identify inventors at the provisional stage, but at the PCT stage we need to make sure that we are naming inventors and that we are not naming people who are not inventors, because these things can be very problematic to fix further down the track in national applications. And now is the time to make sure that we have absolutely got the correct chain of title from the inventor to the company who is applying for that PCT application. Looking a little bit about the PCT application process, just some of the timings. So from our initial local application, typically a provisional application in our case, within 12 months we've got to file the PCT. Within 4 months after that, usually we'll get an international search report and written opinion, which is a really important and useful part of the PCT process. It gives you an early look at what type of prior art is out there, particularly if you haven't been able to do any searching prior to that. And that search and opinion will usually form the basis of examination in a lot of national application offices further down the track. We have the opportunity at that point to respond to the written opinion. It's basically an examination report identifying prior art and identifying whether or not their claims appear to be novel and inventive. At that point, we can actually address those with amendments and arguments. The reason why you would do that is that if you then overcome those objections during the PCT stage, it tends to make for a lot smoother examination in national offices further down the track. Not in all offices, some other offices will do more searching in any case, but for most patent offices that will a clear examination report at the PCT stage will be really helpful. It's important to know that 18 months from your initial filing date, your application will be published, which means it will then be open for all the world to see. So if at some point before 18 months you decide actually we don't want to reveal the details of our technology and perhaps we'd be better off keeping it secret, we'd need to be making sure that we withdraw any applications before that 18-month point. But generally people will be charging ahead. And then at 30 months or 31 months for some countries is then the deadline to file those national applications. Just looking at that PCT International Search Opinion, this is a typical one. This is one from a CSIRO patent application. And you can see on the left there that the examiner has decided that certain of the claims are novel, certain of the claims are not novel, and none of the claims show an inventive step, and they give their reasons for thinking that. Now, these are usually fairly ambit claims at this stage. We usually have the opportunity to amend our claims, particularly if we've drafted the claims fairly broadly, which we tend to do. We can then narrow them down at that stage and explain to them why our amended claims are actually novel and inventive, and hopefully convince the examiner at that stage. And as I mentioned, if we do, then that will make for a much smoother application process in the national offices down the track.
So, PCT process, ambles along. It has a bit of a. It's probably just worth noting that once you start along the patent application filing journey, it's a bit of a roller coaster. So most of these deadlines we mention are not in any way extendable under virtually any circumstance. So you kind of once you're on the roller coaster, you've got to keep riding it for some time. So at the end of the PCT process, you then have the question of national filings and where are you going to file. So there's a live question about geography, and because we can file patent applications in something like 220 different countries or alleged countries, and pretty much no one I've never had a client who wanted to do that. No one in their right mind probably wants to do all of those countries. But at the end of the PCT process, you have a kind of, or at national filings, if you're doing it directly, you've got a one-time only decision. What countries am I going to go to? So the sort of data you need to think about are, where are your potential customers? Where will you operate, manufacture, distribute from? Where are your competitors based, and where do they operate, manufacture and distribute from? Where are your partners or potential buyers, and I'm meaning people who might want to buy your business, and by partners I mean potentially distributors or manufacturers or licensors. Where are they based? And if ultimately an IPO listing, in other words listing, is going to be part of the plan, where's that going to take place? So generally, there's a series of priorities that make sense. So the first one is where the markets are. I mean, our patents fundamentally are, a tool to create a monopoly, and monopolies are about customers and markets. So where are your customers? And that means realistic customers. I mean, people say, well, my customers could be anywhere. Well, yes, but pick the most important ones. Where are you going to have it manufactured? If it's that kind of a product, well, the simplest infringement for it is your existing manufacturer to slip it out the back of the factory. So you kind of need to have some protection where you're going to have it manufactured. Similarly, your distribution partners. Where are your competitors based? It's not the main consideration, but it's something to think about. And the last one is your ability to enforce. So you can get too head up about that. That is pretty much never a reason to not file in China. People have a perception that it's very hard to enforce patents there. It's actually not very hard to enforce unless you wish to sue the Chinese government, which you can imagine ends about as well as you would expect. But at the moment, a good example would be Russia. So if you had a mining technology and you thought Russia was a viable market, you'd really have to consider whether at any point in the next 10 years you were realistically going to be able to sue anyone in Russia and get any money out of them or make them pay a license fee.
Yeah, so because we want to enter the market as soon as possible and want to be ready to be able to assert IP early in the life cycle for the PME product, I recommend filing in Australia and New Zealand initially, and then at the end of the PCT process we would probably look at places like Singapore, Malaysia, Indonesia, Philippines, Thailand and China. They would be probably our main international markets for this product.
Yeah, and in the case of Nosy, it's the markets have been identified, so that leads you to most of the outcomes. So you look at the US, you look at the EU, UK, Australia, China, Japan, Canada, the places you've identified, and you might need to prioritise those depending on your budget. But a particular recommendation here would be that you would look at New Zealand, because Fisher & Paykel's headquartered there, and that's likely would be a convenient place to bring proceedings if that's what you needed to do. So it's often easier to stop, particularly a manufactured product at the base at the start, rather than chase it in multiple countries. So what I'm going to talk about now is just a little bit of an overview of what happens once you start your national application. So the first stage after we instruct someone to file a patent application in a country is that the local authorities will look at formalities. So they'll determine whether you've dotted the I's and crossed the T's, not in the patent application itself so much in terms of substance, but have you put the page numbers in the right place? Are the drawings correct? And have you signed and lodged the correct forms? Sadly, in most countries, there's a series of forms that you've got to get the inventors and the applicant to sign. We don't find that particularly pleasant any more than the clients do, but that's just what has to happen. So the next typical step in most countries is that you have to take a step of requesting the patent application to be examined. In some cases, there's deadlines for this, and they're kind of variable from country to country. In other cases, like Europe, that's just a step you have to take as soon as you file. The examiner then conducts a search of predominantly patent literature and issues a substantive examination report or official action. That's really the same thing. And that will raise a variety of issues. We'll talk about those in a little bit more detail in a minute. Then, in response to that, we file a response that's usually a mixture of arguments about why, basically telling the examiner why he's wrong, amending the claims to assist your argument as to why the examiner's wrong. And then there may be a further stage, so another examination report will issue. And that can go on, it depends on the degree of objections you're getting and how well the invention sits relative to the prior art and just the foibles of the particular examiner. But 2, maybe 3 rounds with the examiner is fairly typical in a jurisdiction like the US or Europe or China for that matter. So we go around again with the examiner. In some cases, you can have an interview with the examiner, and that can be particularly good if you think the issue is the examiner's just not understanding the invention, or sometimes just isn't understanding what's actually in the prior art document. Because, the examiner's got a limited time budget generally to do an examination, and they're not necessarily, they're not going to spend 40 hours analysing a document. They don't have that amount of time. So sometimes you need to help them. There are appeal options. They're rarely necessary, but it's good to know that they're there and they help to keep the examiners honest. Interestingly, they can be particularly useful. There's a sort of a re-examination option in China, and that can be very helpful to put the examiner back on track. So once the examiner is satisfied, then they'll issue a document that says the case has been allowed or accepted, and that just means the Patent Office itself is satisfied. The application gets published to allow for possible opposition. So it's put out there basically saying this is the patent we're going to grant unless nobody objects, and third parties can intervene and oppose. That's again fairly uncommon. It's less than 1% of cases would that occur. You then have grant fees to pay, and you get issued a certificate, which used to involve lots of lovely seals and ribbons and things, but now is just electronic, so it's a bit less satisfying, but a bit more efficient. So just to talk about a few particular countries and what happens. So in Australia, you have to file a request for examination. You can either do that whenever you like, at the time of filing even, or you can wait until you're directed to request examination. I mean, theoretically you have to do it within 5 years, but that never happens because you get directed. So the direction is just the Patent Office managing its own workload and deciding when it would like some more cases to hit the examiners. You can accelerate. So once you file a request for examination, it's somewhere between sort of 8 and 12 months before you will get an examination report. There is an option to accelerate it, which doesn't cost very much money. You really just mainly have to ask. Again, if you're in the pair me situation, that's what you would do. In nosy, you're really probably in no hurry to bring things to a head. The first official action sets a 1-year deadline for acceptance. You can go backwards and forwards as many times as you like with the examiner. You can have informal discussions with the examiner, which is unusual. In most countries, they have a very formal process for interviews with the examiner, whereas we just ring them up in most cases. In an extreme case, things can proceed to a hearing, or if you're getting close to the deadline, there's a process of filing what's called a divisional application. So a divisional is a filing that is, in principle, to allow you to protect, if you've got more than one invention, to allow you to protect the one, to file a divisional application directed at additional inventions that you've disclosed in the same document. But in Australia, we can just use that as a way to essentially restart the clock. And so once the examiner is satisfied, it's published for possible opposition once it's been accepted by the Patent Office, and the process continues. So it's a fairly straightforward sort of procedure. So again, continuing with our theme that these are nothing to do with us or our clients, and B, they're actually mostly CSIRO cases, because I figure we as the taxpayers have paid for them, so we might as well have a look at those. Just an example of what the guts of an Australian examination report would typically look like. It's fairly matter of fact. In Australia, they would typically run for a few pages, as opposed to other countries, which we'll talk about in a moment. But it's it tells you where you stand essentially. So the US, it perhaps comes as no surprise, has an entirely idiosyncratic body of law and an entirely idiosyncratic patent procedure system, which slightly laughably is described as compact patent prosecution. It was introduced in the 1950s to speed things up, and I think any objective study of their system would say that it hasn't sped anything up, it just makes you go around in circles. So what happens in the US is there's no separate examination request required. You pay a fee for that when you file. And the examiner eventually gets around to looking at your case. It is possible to accelerate that, but I won't go into that at this stage in this talk, frankly. So the initial action is what's called a non-final official action, and which will only make sense when I explain to you what a final action is. But anyway, they are called a non-final official action. You normally have 3 months to respond. They tend to be very long documents, US examiner reports. They often run to more than 30 pages. They use a lot of very fixed objection language and what in another context you'd call boilerplate about this is the law and this is how it works. Then you've got to sift from that the actual objections. But they do tend to be quite thorough. When you file a response, a particular feature is you've got to address all issues. So in Australia, you might decide to just address some of the issues in a particular response and worry about the other ones once you've solved the big problems. In the US, you actually have to address all of the issues, or you can be deemed non-responsive, and so as if you've never filed a response, which is obviously not a good outcome. But the US, you generally need pretty complex submissions and amendments because that's the way the objections are made. So after you've responded to your non-final action, you get 19 times out of 20 you get what's called a final action. And the main significance is that you have reduced options for response. the examiner has more discretion to not accept amendments. Now, all the way along this process, you can hold an examiner interview, which tends to be a reasonably formal process, and that can be a pretty effective way to move things forward. But the most important thing about a final action is there's not final at all. It's just final in this little piece of the cycle of prosecution. So it's just the examiner's not going to be as responsive as he was, or he or she was. And generally what happens is after you've responded to the final, if you're not getting anywhere, you file what's called a request for continued examination. And that's really a way to collect another modest fee from the applicant, and then after that you'll get a new non-final action. So typically in the US, the statistics are you on average do about 2.5 responses, so between 2 and 3 in most cases, though it can easily get beyond that. It can also often only be 1 response depending on what the issues are. There are a variety of appeal processes. They're pretty slow, and for that reason they can be a pretty good way to buy time if that's what you're trying to do. So you can file an appeal, and when you file an appeal from an examiner's decision, the whole thing flicks back to the examiner and creates an enormous amount of work for them. They essentially have to put all the documents together and develop their arguments to go to the appeal board before you have to do anything, and so that usually takes months and months and months. And while that's happening, you could file continuation, which I'll explain in a minute. So a continuation is just a way to file something that gets a new application number but keeps the same dates. It's kind of a child, if you like, of your application. And it's a pretty widespread part of US patent strategy. You will at times find a patent or a patent application that's the end result of 8 continuations. So it can be part of a game to avoid a hopeless patent lapsing. It can be part of a game to let some parts of a patent go to grant and keep it pending so that you've got more flexibility in the case of infringement, for example. So it's quite a useful strategy. Of course, if you're, it's not going to be cheap if you want to file lots of continuations, but it is part of the game. So at the end of the US process, you get a notice of allowance and you get reasons for allowance. And the reasons are quite important because they're something that the court will, in the fullness of time, if you have an infringement, use as part of the interpretation of your claim. So sometimes the reasons for allowance are not what you would like the reasons to be, and you actually have to go back to the examiner and argue with them. The other particular point in the US is, going back to the US being, a bit special and a bit different than everywhere else, is that they have particular rules around inventors and the sort of formal oaths and assignments you need from them. They come very much from a position that the inventor is the prime party. Until a relatively few years ago, you couldn't file in the name of a company. You had to file in the name of inventors and then assign the patent. The claim formats, the drawing rules, they're all a little bit different to everywhere else. So makes things slightly more expensive always there. And this is a little example of the summary page. Not really the actual objections, but the summary page of a US official action on a CSIRO case that runs the objection. This one runs to, I think, 36 pages. So just to give you an idea of what it looks like. So I just wanted to talk about Europe. So there's kind of a variety of concepts here. There's what is Europe, and I'm not going to get into the microcosm of geography, but there's the European Union, and then there's a whole other set of countries in Europe that aren't in the EU. Most famously, we would all be familiar with Brexit and as an ex-member of the EU, but other important countries, like, depending on the industry you're in, like Switzerland and Norway and Iceland and indeed Turkey are not part of the EU. But there is something very powerful called the European Patent Convention, which all of those countries are. So everything that's in red on that map is a member of the European Patent Convention. The ones in the kind of tealy blue colour are what are called extension states, and that means you can tick a box and include them as well if you want to at the time of filing. Kind of perversely, that includes Cambodia, but mainly contiguous countries. So the European patent system allows you to file a single application at the European Patent Office, and that will proceed with a single set of examination and procedures to say, okay, we will grant you this European patent with this set of claims, and then you have a validation process after that, which I'll work through fairly quickly as we're getting towards the end of time here. So there's 38 countries in the EPC. It is quite bureaucratic, but consistent and mostly pretty high quality decisions. So what happens is after you file, you get a European Patent Office search and opinion, which isn't exactly an examination report, but it's, if you wish to after that, if you think, oh my goodness, I'm never going to get anything, you can withdraw and they'll give you some of your fees back. That's almost a unique feature of Europe. Nobody else will ever give you any of your official fees back. The government's got it and then it's not coming back. So after that opinion, you've got an option to do amendments and you've got to confirm that you want to proceed. A particular feature in Europe is your ability to amend is somewhat constrained. You can't broaden a claim. So, claims are a lot like mathematics. If you say, my invention has A plus B plus C, and that's the broadest claim you have at the PCT stage, and you get to Europe and you actually decide, C is not that important, I want A plus B plus D, you will not be able to sustain that claim. So you're as opposed to Australia or the US, you might be able to get away with that. So this is what a European examiner's report looks like. Again, not dissimilar maybe to an Australian report rather than a US report, but it's kind of chapter and verse laid out for you. Here are my problems with your case in fairly, I think it's probably fair to say, sort of fairly Germanic manner. There's not much, there's not much politeness about it. It's quite direct. So then you get an official action from the European Patent Office, which I've just shown you. You get 4 months to respond. You go backwards and forwards with the examiner several times. They're not necessarily quick. It might take you months or, in some cases, years from when you file a response to when you hear anything further. And you can go backwards and forwards with the examiner. If the examiner decides the case is not progressing, they will summons you to an oral proceeding, which is really just a fancy word for an interview, but that's what they call it, being the European Patent Office. Assuming you progress successfully, they will issue something called an intention to grant and give you a proposed text, which the examiner may have made some amendments in, so you do need to check that fairly, or we need to check that fairly carefully. And that sets the timeline for what has to happen for grant. So you've got to approve that text or go back and argue why the text is no good. You've got to pay the European grant fees, and you also have to file translations of the claims into French and German. And at the end of that, the European patent is granted. But as I mentioned before, that's not really the end of the show. So you then have to decide where you want to validate, and then you go back into that same process in part that we talked about in terms of picking countries, working out where's important, looking at where your competitors are, where your markets are. And there's really two basic ways to go about validation. The first option is country by country, so you just pick which countries you want. Some of them are fairly inexpensive to do the validation in, hundreds of dollars. Some of them are thousands of dollars because they require varying degrees of translation. Some countries, 7 or 8 of them, normally require a translation of the whole text into their local language. And if you imagine, doing that for multiple countries, it can be pretty expensive. most commonly people end up validating in somewhere between 5 and 10 countries in my experience, out of the 38. So the second option, and I apologise for the somewhat opaque language, but this is, the European Union we're talking about, has something called the unitary patent, and they've been working towards this for no less than 40 years, and it's only really come into effect middle of last year, I think, effectively in being operative. So what this allows you to do is, at the end of European procedure, say, right, I would like a unitary patent, please. And at the moment, it extends to 18 European countries, 18 members of the EU, rather, so it's not all members. It's really cost effective because you only have to pay for one full translation. And you can pick the cheapest place to get a translation done for that. It also leads you into a unified court system, which means you can go to one court in Germany, say, and say these people are infringing, I'd like an injunction for all 18 countries, and they can grant that to you. So that's pretty powerful. But not all so two things, obviously, well, maybe not obviously, non-EU countries are not included, and some of the EU countries have said they will not participate, the big ones being Spain and Poland. A selection of other European countries will participate, but they're going through, you can imagine this, the linkage to the court system makes it a bit problematic, so that they have to amend constitutions and all sorts of things. So it will expand beyond 18 countries, probably to about 25. But it's very cost effective. It's way cheaper than country by country. So quite, our experience has been that most clients, maybe all clients, I think, since this has come in, have been using the unified patent system, because we certainly encourage it. The unitary patent. Quite commonly it's that plus a direct filing in the direct validation in the UK, or maybe in Spain as well. So it's that's the most common outcome. But I'm sorry, there is a bit of bureaucratic madness to get to there. So in the case of Nosy, what I would recommend is you do the unitary patent, you do the UK, you'd probably do Switzerland as well, because it's a pretty key place in terms of medical devices, and it's pretty inexpensive. It doesn't need any extra translations. You could look at Poland and Ireland and Spain, depending on what you thought about the market and where people were manufacturing. Ireland being pretty inexpensive, Spain and Poland being expensive. So common examination issues. I'm just going to run through this fairly quickly. So just an idea of the sort of things that are going to come up. So a lack of unity, which is, I appreciate pretty dense patent nonsense jargon, but the point is the government only wants you to grant you a patent for one invention. If under the rules that they apply, the Patent Office thinks your claims cover more than one invention, and the most usual definition of that is that they all relate to a common new inventive concept, then they'll object that you lack unity in your application. But as you might imagine, each Patent Office has a different set of rules around this, and it's applied more or less rigorously and just differently. There are a set of, to my mind, quite arbitrary rules in the US, for example, about what has unity and what does not. So this often comes up very quickly, or not very quickly, immediately before examination proper commences. The examiner will say, well, you've got 50 claims. I think these 15 relate to one invention, these ones relate to another, and these relate to another. And you can, to some extent, argue the point, but you've usually got to pick one of those to have it examined, and then decide later on whether you're happy for the other aspects to just be dependent aspects, so in other words, not standalone inventions, or file a divisional application, which I explained a little bit earlier. So novelty is it new? And that's actually assessed in a fairly mathematical way. It's novelty is assessed against a single document or a single prior use or publication. So claims say A plus B plus C. Does that single document teach A plus B plus C or not? It's pretty much as clean as that. You might get a little bit of wriggle room on interpretation of the document based on the knowledge of the person skilled in the art, who would understand that, well, this earlier document said, to build it with a Phillips head screwdriver, but actually you could do it with a slotted screwdriver or something, something very minor like that you might wiggle around. But anything more dramatic than that, you're not able to the examiner is not able to assert novelty. So essentially, if you really genuinely got a novelty problem, that's a pretty big deal. You've usually got to amend to add extra features into your claim to get around it, or to argue that the examiner's wrong and it doesn't teach anything of the sort. The big sticking point in a lot of patent applications is inventive step and obviousness, and there's no really simple way through this. So for this purpose, in most countries, the examiners can combine more than one document, and the examiner will normally consider themselves to be the person skilled in the art, whether they really are or not. In our experience, the examiner's a little bit loose and free with what they think the person skilled in the art might know, and so they will assert that your claims are not inventive. So there's a bit of a circular definition here. In the US, it's called obviousness, and something is said to be obvious if it doesn't have an inventive step relative to the prior art. In Australia, we talk about whether something lacks inventive step, which means that it's obvious having regard to the prior art. So, I'm not sure which one of those is the least helpful, but anyway, that's what we're stuck with. So there's an inevitable aspect of subjectivity here. And it's really a matter of trying to minimise that and exploit that to respond. So here's some of the things we would typically do when we're trying to overcome obviousness. So one is just to amend the claim. So the examiner might be reading a claim in a way which we think is clearly ridiculous, and so you put some terms in the claim to clarify it, so that interpretation isn't possible. You can argue that the examiner's added together these references, but actually if you add them together, they teach something completely different than he says they teach when you add them together. So for example, they might be very selectively adding very small components, whereas really the teaching of one is not what the examiner wants to say it is. You can argue that the references he's adding together are not technically compatible. So one says that feature X is absolutely essential, and the other one teaches that feature X must be avoided at all costs. So you'd be surprised at how often that occurs. Or that it's just such a remote field that no one would add one and the other together. You kind of back off options of things like finding a learned article that says that the claimed invention absolutely will not work. I've had that happen a couple of times. It's very helpful when you actually then, that is your invention and it does work. Or if you can prove that there's a long-standing technical problem in the field and you've solved it, even if they're now saying you could solve it by this obvious combination of references, it becomes, well, it can't be obvious because everyone thought there was a problem and hadn't solved it. Or you can run an argument that the main reference that the examiner is relying on actually solves a completely different technical problem to the claimed invention, so that the person skilled in the art would not even consider it relevant or somewhere to look to solve that problem. Again, not an easy argument, but quite successful on occasions. So it's almost the point of this slide is partly, if we get obviousness objections, they seem terrible on first reading often, But, the main point is don't panic. There's ways to deal with these things most of the time. So just to touch on a few things beyond the patent application process itself. Renewals and annuities, they're just something you need to be aware of. Governments charge fees. They charge them on an annual basis mostly. Sometimes they're before the patent's granted. That's how the European Patent Office survives, is on fairly large fees while the application is pending. Some countries only charge them after grant, so the US, for example, and some have a bit of a game in the middle where you don't have to pay them along the way, but at the point of grant they add up what you would have had to pay if it was granted earlier and hit you for a lump sum. So the annual fees increase over time, the logic being you've had the patent, you should be making money out of it by now. But that's in terms of the complexities of when they're due and what have you. That's something that we manage our systems, keep track of all that, and we send reminders and what have you as we need to. But it does cost money every year, and there's no getting around it. You can pay them late, but then you're paying extension fees, and that's a complete waste of money if it's best avoided. We touched on this briefly, but just to harken back to, it's one thing to get your patent, you've got to make sure you can actually implement it, and that's something you might need to come back to. If you change the territories that are of interest, or you're going to change the way you make or you market something, or how you package it, pieces together. So no one wants to be to walk into a brick wall really in their product launch.
Yeah, it's important to remember that it is possible to have a patentable invention yourself, and still using that invention or selling it infringed someone else's patent. So the patents can overlap. It's just important to remember that.
Yes, I mean the old saying is that we all stand on the shoulders of giants when we develop our products or develop technology. Those giants might own patents is the problem. So you just need to be particularly conscious, to throw to my little example, and my friends at Nosy need to be conscious of that, and maybe even institute a watching brief to see what the main competitors are doing in terms of new filings in these spaces, because if they can stop them, if they're successful, if they can whack them, they will. It's not a complicated concept. So, sort of a final point about strategy is that this stuff isn't set and forget. I'm sure there must be an example, I can't think of one, with a client whose product that is on the market in 5 years' time is exactly the same as it was on the day that we first met them. The product changes, how the service is delivered might change, what countries are important change, what's important to the market. It is also really commonplace that what someone initially thinks would be the most important feature in the market isn't. It's some other feature as they go along, and that might need us to put a different spin on the patent application. The same with territories. Maybe you imagine some territories will be successful and they're not. So this sort of ongoing communication about what's going on in the business, not just responding to us saying, hey, you've got an objection, is really important to get us in a position to contextualize our advice, I guess, and make it work with your business context and your business plans, because we're often recommending a course of action out of theoretically might be 6 or 8 different things you could do. If we have a good understanding of your business, we can probably discard a whole lot of those options, so we're not wasting everyone's time suggesting things that we know are useless. So there we go.
Oh, well, thank you, everyone. Hopefully you've managed to last through to the end there. There's a lot of information there, I know, but hopefully it was useful, and we're going to hang around now for any questions or any other discussion you'd like to have on the basis of what we've just been talking about. So please put them through on the chat, and any questions that come through, we're happy to answer.
So,
as of right now, we don't have any. So,
so we can take that as either we've been extremely thorough or everyone's lost interest. So we'll just assume that we've been extremely thorough. We'll give everyone about a minute, and then we might just thank everyone. So I guess one point that I think is worth coming back to a little bit is the importance of what you disclose in that first patent application comes back to, it's something that you're not only stuck with, but it becomes the playground, if you like, within which you can amend and which you can play around later on to overcome an objection. So, when we're saying, can you tell us this, can you tell us that, it's not, will the world come to an end if we don't have it? It can sometimes be, well, we don't know that, but we're just trying to optimise our ability to adjust later on if things happen that we haven't currently foreseen. And so,
yeah, because at the outset we don't know what an examiner's going to throw at us 5 years down the track, and so it's very useful if we've got other information that we can pull out of the patent application to address those issues or that prior art later on. So, no one's got a crystal ball. We'll never know exactly what's coming at us down the track, but the more information we have to work with in the patent application, the better placed we'll be.
So, okay. Well, we're not overwhelmed with questions, so thank you all very much for your time. We'll bring that all to a close. If you've got any questions you want to email us about afterwards, we'll be very happy to address them. And thank you all for your time.
Thank you. Thanks, everyone.